We have a question from Representative Allen.
Yes, sir.
Thank you, Madam Chair. This question is for Mr. Gallis. Mr. Gallis, would you agree that several years ago, the state of Arkansas ran in front of the federal government and took on an issue that we should not have taken on? And would you agree that we're still paying for it today?
And what issue would that be?
With the school system.
Well, see, the problem with the school issue was not whether or not we made the wrong decisions. We failed to make a decision. If you understand the history behind Lakeview and that, it was because our government, you, or not necessarily you, but your people who were in the past, those representatives, failed to make a decision, which is why we had that lawsuit. And by the way, which is why we are asking another $55 million this year to pay for that. It's not good enough to say I'm afraid about the lawsuit. It's what is right and what is wrong. And always, it's your job to protect the rights of the citizens and the sovereignty of this state. And I believe that voting against this goes against that.
Representative Hyde, you have a question?
Yes, thank you, Madam Chair. Sir, I appreciate your statement that it's an opportunity to make a statement here today. But you see, we don't really have an opportunity to make a statement today. The mechanism used in this body to make a statement is called the resolution. So what we have before us today is not a resolution, it's a proposed law. And there is a marked difference. And actually, for what your purpose is, your state of purpose, to make a statement to the world, a statement to Arkansas, a statement to the federal government, is not through passing the bill. It is through passing a resolution. Thank you, Madam Chair.
The passage of this bill is indicative of your thought or of your principles about whether or not you think health care insurance should be mandated by the federal government. It is a test, and it is a way to evaluate whether or not you believe the citizens of the state of Arkansas have the right to choose to spend their money as they see fit.
Thank you, Mr. Gallis.
Thank you.
I'd like to give my time to Dan Greenberg. David just asked me if I can turn that over.
Certainly.
Thank you.
Mr. Greenberg, take place at the table and introduce yourself for the record.
Thank you. My name is Dan Greenberg. I'm an attorney here in Little Rock, and as I imagine some of you remember me, a former member of this body. And I want to begin by saying I thought the talk that introduced this bill by Representative Meeks was really covered a lot of ground, but I was disappointed to see that for some people who spoke after him, it was as if he never spoke, because he made it pretty clear that this is not really an issue that is going to cause constitutional problems. Let me just address some of the things that have already been said by other speakers here. Ms. Block from the Attorney General's office said this measure would have no legal effect. Let me tell you the legal effect it will have. It gives standing to citizens of Arkansas to take up this issue in court and pursue a rapid remedy such that we can get this thing resolved and we don't have to wait around in legal limbo for 4 years or 8 years or however long it's going to take to get to the Supreme Court. It's going to eliminate the uncertainty, or move towards eliminating some of the uncertainty that we face. And of course, standing up for the rights of Arkansans to be protected in our courts is a central job of the citizens of Arkansas as represented in their legislatures. I want to say just a word or two also about the Supremacy Clause. Ms. Block brought up the Supremacy Clause. The Supremacy Clause is not applicable when the Congress does something that it's not empowered under the Constitution to do. Federal law only trumps state law when federal law is constitutional. The whole question is whether a mandate is constitutional. So there's no Supremacy Clause issue. I also want to say a few words about the significant state resources that Mrs. Block talked about that might be involved if we went to court. You know, 2 and 4 years ago, I remember a great deal of discussion about the Equal Rights Amendment, which was another piece of constitutional litigation. And I never heard any, I followed the debate closely, I never heard any discussion of the cost of the Equal Rights Amendment. There were some supporters of the Equal Rights Amendment. I think that at least one legislator who was a supporter is actually in this room, and I believe another supporter of it was our Attorney General. I never heard any discussion of the cost of this constitutional litigation except by one person when I actually asked Dean DePippa what the cost of it would be. He said, and I'll just repeat what I recall that he said. He said, you know, the costs of this litigation would be very minor because this is constitutional litigation. It's not the sort of litigation that involves a lot of scientific tests and expert testimony and so forth. It's just basically, you know, constitutional litigation is basically a couple of lawyers sitting around the law library writing and thinking. That's all constitutional litigation is. It doesn't require a lot of scientific tests and expert testimony, so it's relatively cheap. And of course, it's also budgeted for in our current budget. So I think the cost argument is I'd say it's a red herring is perhaps over-complimenting a little bit. I want to say